I'm meeting with Jeremy Atwood today, who is a bankruptcy and divorce attorney in Ogden and Weber
Davis
counties and
County.
Davis counties. And so we're going to be talking about where divorce and bankruptcy often overlap. So to make sure that we cover things quickly and in a way that people are going to benefit from, where do you want to start with some of the things that do you want to just talk about some of the concerns that may come up when a couple may be divorcing because of money trouble, where they may
Sure.
want to consider how bankruptcy could affect them at the same time?
Well, to start off with, let me just briefly mention the options for bankruptcy are generally Chapter 7 and Chapter 13.
Okay.
Are the two individual things that most people can file. The other bankruptcies you hear about don't.
Right.
Chapter 11 is a big business reorganization and whatnot. Chapter 7 and 13 are the ones most people file. Chapter 7 is a liquidation. So what that means is that the bankruptcy trustee will look at all of your assets to see if there's anything worth liquidating in exchange for your discharge of your debt or whatever's left over. So that is the most common, the least expensive of the bankruptcies often, but there are some differences that can cause problems, and you want to talk to a bankruptcy attorney in order to have a good idea of which is best for you.
Before we go there, then any further, so Chapter 7 is saying we will discharge your debts, but the price of getting your discharge is we'll take all your assets with some exceptions, and then we will.
All is a pretty strong term.
With some exceptions.
Of
We'll,
course.
we'll take all your assets, but I'm simplifying it for that. We'll take all your assets, liquidate those, and then we will hand out that money to your creditors standing in line until it runs out.
And then a discharge of whatever is left over.
Yeah,
right.
and then everything else. And so all the creditors don't get a percentage. Some get a little, some get all. Many creditors will get absolutely nothing.
Absolutely.
And then those exceptions I talked about, let me make sure. There are things where you might be able to exempt your house. You can, what's it called, reaffirm? Is that right?
Reaffirmation
Yeah.
is a contract you sign to be liable for a debt after the bankruptcy.
Right, so you can
Yeah.
keep your house by reaffirming that debt, or you can often reaffirm
Or
your
car.
car loan.
Sure.
But there are, you
RC
can't do it.
Willie's.
Can't do it for everything. But the idea is that some things you may be able to carve out so you don't lose your house and home. Sometimes you do lose your house or home,
You can.
or car. But the idea is take your assets, liquidate them, hand them out to the creditors as to what's left, and then all your debts are forgiven. And then the exception there would be like student loans or not. Although I know there's going to be some things that are.
There's a few laws about the student loans, but majority of the time you can't get rid of those. No,
Okay.
otherwise a lot of people would file right
Right.
after they finish school. I might have done it myself. I have a lot of those. So the one thing I want to dispel though is the idea that you're going to lose everything. I have people all the time that call me about bankruptcy.
That's what I
and
wanted
they-
to talk
and
about,
they worry
too.
about that.
Yeah.
And most of my clients lose nothing. One of the things that comes up certain times of the year is your next tax return. If you get a large tax return, then they're likely to hold out and look for that in the future. But they can only take what you've earned as of the time you filed. Your estate, your bankruptcy estate is created the moment you file. What are you entitled to at that moment? And when it comes to a tax return, the way you would deal with that, they have to prorate it. So they'll take your tax return, divide it by how many days there are
The
into
tax
the year,
the tax refund,
the refund
you've
amount,
got.
divide it by how many days there are into the year, and figure out how far into the year were you when you filed. They'll take that portion of your refund. So if you're halfway through the year, they're going to take half your refund in Chapter 7. Chapter 13 is totally different.
So
on the way
is
that's
December a
going.
big month for bankruptcy filings if people have big tax refunds?
People generally avoid filing towards the end of the year because it's more likely they'll lose it. Oftentimes what happens is they'll wait until they get their refund, they'll spend it appropriately, and then they'll file right after their refund
see.
is spent.
Okay.
So that is a common practice. They're asking for refunds earlier and earlier in the year, I've noticed as of late, and so it depends on your trustee and
Okay.
their interest in waiting and keeping the case open. So Chapter 13 is a much different. Chapter 7, though, you don't lose everything. There are a lot of
Yeah.
exemptions that cover most of your stuff, and really it has to be something the trustee's interested in that's worth their time. They're not going to waste their time for a few $100s.
And briefly, the trustee is the person who's in charge of gathering everything up, liquidating it, figuring things out, because the trustee takes his or her slice out of your bankruptcy estate.
They
as
have a
well.
portion that they're entitled to, and all the cost of doing the work comes out of whatever they get. So you don't end up having to pay anything extra. It's part of the process. Whatever they get paid, they take out of what they received from the estate.
That's good to know about 7. Now you were going on about chapter 13. That's
Chapter-
not a discharge. What is that?
Well, there is a discharge at the end. It's the same that way in the end. It just, they get to it
Okay.
in a very different way. Chapter 13 is a repayment plan for a 3 to 5 year period. By no means can it go longer than 5 years,
Okay.
60 months. So your plan payment will establish, all the ins and outs of who gets paid and what they get paid and the percentages and whatnot. Your payment in a chapter 13 is going to be based on your disposable income. So if you picture a scale, on one side of the scale you will pay your disposable income. What is left over after you pay for your living expenses, your mortgage, your utilities, your food and your clothing, your laundry, dry cleaning, your medical expenses out of pocket, your transportation costs, car payments you're going to continue to have,
And may I ask,
insurance,
is
all
it,
those things.
is it your payments for the lifestyle you're accustomed to prior to filing for bankruptcy, or is it
It's your
kind of
current
minimums?
continuing expenses. I have clients that have house payments that are $3,000 a month, and then I have some that are $1,500 or less. And so it's what you currently pay out. If you want to have a house that has a really expensive payment, then you get to have that come away from your income and help you determine disposable income. So on one side you will pay your disposable income. On the other side of the scale, you have to pay what the law requires in order to make your plan feasible. So there's a lot of laws and rules that say what has to be paid and doesn't have to be paid. If you have a house that you're behind on, then your arrearage payment. If you want to keep the house, the one benefit of a 13 is that you don't have to be current to keep a home. You can catch up in that repayment plan period. So you continue to pay your regular monthly expense on your house, but then the amount part of your plan has to be that arrearage amount. You got to catch up. So that's got to be over here too. Then you have your attorney's fees that weren't paid up front. You have your trustee fee. You have other things that need to be paid. If you have a lot of assets in a 13, you have to pay at least what you could have lost if you had been in a Chapter 7 discharge or liquidation. So if you have a car that would have been sold or could have been sold in a Chapter 7, you have to pay at least that much to your unsecured creditors in a 13 to make it
The idea
fair.
being that we would have liquidated it in the 7, so you...
It's not fair that the creditors get nothing because you decided to do a 13 instead. So they have to be paid the same to make it fair for them. And so you have to balance these two sides. What has to be paid under the law, and there's a lot of things that can come into what that number happens to be. But you've got to check this side and see if you can balance the two and have your payment be something that you can afford. So you have to have enough disposable income to pay this.
And it sounds to me like when a 13 is filed, everybody involved, creditors, trustees, and even the people filing, the debtors, they have to come up with a plan that has a losing chance. You can't just hope for the best. It's got to be something that everybody's convinced is going to work, or they won't allow you to file Chapter 13. Is that correct?
When you file a 13, you have to convince everyone that it's feasible, or at least a judge. If people object to your plan, then you can go to a hearing and fight about it in front of a judge, and the judge can decide. Usually the cases will be confirmed by consent, where you try to eliminate those
You negotiate
concerns.
with everybody to say, is this a
Exactly.
plan we can all get on board with? Okay.
Yeah, you try to fix the problem so that it'll be able to pass through and be confirmed by a judge.
It's good to know.
But if there's objections, you have to try to fix those, or you have to argue them in front of a judge to try to see if you can convince the judge of your position.
Okay, let's talk about a couple things then. Some myths that I get asked a lot. Well, what I'm going to, and I'll just, I mean, I don't literally have people ask this, but what I'm going to do is I'm going to file for divorce. I'll be happy to take on a certain number of debts, but then I'll just file for bankruptcy and leave my spouse holding the bag. So, if you want to start there?
That doesn't quite work.
Okay.
That doesn't work, and it really depends on what chapter you file. There is a difference between what you can get away with in a bankruptcy and what you can't, depending on which chapter. Well, first off, let me just say that your bankruptcy will wipe out your legal obligation to the creditor. not necessarily to your ex-spouse through a divorce decree. So if you picture a triangle, if the creditor's at the top and you're here and your wife is here and you both have obligation to the creditor, if you file bankruptcy separately, it'll wipe out your obligation to the creditor, but then you might have a line to your ex-spouse through your decree, and they can take you to court for failing to follow your decree. So depending on what you file, there's an issue there. You can always file jointly prior to your divorce being finalized. As long as you're legally married, you can file together for the same cost as an individual can file separately. The benefit of that is that you don't have to worry about one of your issues in divorce, who pays for what debts. The bankruptcy can eliminate most of that issue.
Now, obviously, if you've got $7,000 in debt, you may not want to file for bankruptcy.
It probably wouldn't be worth your while.
But if you're drowning in debt and you're afraid that your spouse may try to stiff you or leave you holding the bag,
right,
you could just go to your spouse and say, well, before we divorce, let's file for bankruptcy.
Absolutely.
Let's make sure that our debts are discharged so we have not only a fresh start as debtors, but also a fresh start as newly single people, which is huge.
Right.
And then on top of that, let's also make sure that neither one of us can stab each other in the back by just trying to bankrupt out, leaving the other person solely responsible.
So really, you take out an issue and you really help yourself out in starting, because who needs the extra? Divorce is stressful anyway, especially if you have children involved. And so if you're able to wipe out an issue of debt, that helps a ton.
Can you, what would be the best way to time it? Do you file for divorce and bankruptcy at the same time? File for bankruptcy and then for divorce? You can't file for divorce and then joint bankruptcy.
Right. You would have to file separately. And the problem with that is that your divorce decree will have to lay out how the debts are dealt with.
Mm-hmm.
You can put in there that you're both going to file bankruptcy, and you can put that in your decree. I've seen that. But in the bankruptcy itself, you can only file jointly if you're still married.
Okay.
So as long as you file before the decree is entered, then you can file together for one cost. If you file separately, you've got double the cost. You have two separate bankruptcies.
And you handle both bankruptcy and divorces.
Right.
What would you prefer to do? File for bankruptcy and not file for divorce until the bankruptcy is done, or file for bankruptcy and then file for divorce, or file for divorce and then file for bankruptcy and have them going concurrently? What if you had your druthers as the lawyer, what would you see done?
I'd like to see the issue off the table for divorce. So if you can file jointly prior, then it just takes one issue completely out. I think it's a really smooth way to go. The thing you have to watch out for is, I've had people come to me and say, well, file our bankruptcy, so I'll file it. The problem is I'm representing both of them in a bankruptcy.
Uh-huh.
Then I'll have one of them come to me and say, well, I want you to represent me in the divorce. Well, I can't. If I represented both of you in the bankruptcy, I can't represent one of you in the divorce, so you have to choose between me as your divorce attorney or your bankruptcy attorney. And whichever you want, I turn the other over to someone else, such as either yourself or another bankruptcy attorney.
But that has its rewards, because then they know you can't use the knowledge of both spouses to use it against one of the spouses, which is avoiding a conflict of interest if you didn't figure that out already.
Right.
Okay.
So yeah, I can't have a conflict there. So I like to have the issue off the table. If I was dealing with a divorce, I prefer the less issues, the more likely you are to
So the
settle.
bankruptcy's filed and done, and then we file for divorce.
I don't know about you, but you'll go through a mediation, and one of the issues is who pays for what debts and how much. That can be a really contentious issue that people have a hard time with. And if you can take that issue out, you're more likely to settle. So it's a good thing to be able to get that out of the way if you can.
But what I'm saying is, are you saying file for bankruptcy and complete your bankruptcy proceedings, then file for divorce, or simply start the bankruptcy proceedings, then start the divorce, and then don't have the decree signed off by the judge until the bankruptcy is done? Well, that's what I'm asking.
The benefit of filing the bankruptcy prior to starting the divorce is that the issue is gone and doesn't even have to be discussed.
We were married, no question about it.
If you start the divorce and then you determine bankruptcy is an option later, you're still possibly going to be paying your attorney to discuss with the other side the issue of debt. And then bankruptcy is an option, so you can definitely do that as long as you're not finished married yet. Preferably, you don't even have the issue at all, and then you don't have to pay your attorney to even discuss it as a problem in the divorce. So preferably, I would say you'd file your bankruptcy first, just so you don't even have to pay money to discuss it with somebody. Because as a divorce attorney, people are paying my hourly fee to discuss the issues, that's one issue they don't have to discuss if it's already been taken care of.
At what point should people say bankruptcy? I mean, it's funny. There are some people that just will declare bankruptcy at the drop of a hat, but we're not talking about those kind of people. What are some of the things like? Where can bankruptcy help credit? Where can bankruptcies? Because there's still some stigmas. Not as much as there used to be. It's not as hard to declare bankruptcy and move on with your life as it was, say, 20 or 30 years ago. But what are some of the benefits to somebody going through bankruptcy when it comes to their credit?
Sometimes bankruptcy is better for your credit than not. Mainly, it's based on your ability to pay your debts. Bankruptcy dings your credit, but it's one ding. It's a good size one, but it's one. Non-payment on debts, the dings they get you monthly may be less of a ding, but if you get enough of them, they can be bad. So if they ding you monthly, every month for non-payment of your debt, over a long period of time, that'll be a lot worse than a bankruptcy ever would be. So if you file bankruptcy, it'll ding you, but then you can start rebuilding it right away. Whereas if you aren't paying your debts, you're going to slowly be going the wrong direction, and it'll get worse.
And slowly digging yourself into the deeper.
And then if you end up having to file bankruptcy anyways, you have the long time you've been avoiding it, hurting your credit, and then it hurts it more with the bankruptcy. Whereas if you see the writing on the wall, my favorite clients are the ones that can see ahead. And I know I'm not going to be able to afford this. I'm not late yet, but I will be. And so they see the writing on the wall. Their credit's still good. They'll file bankruptcy, and that's the only ding they have.
That'll be the only ding. They cut their losses.
They cut their losses, but they see it ahead of time.
Yeah.
Some people avoid bankruptcy for years. Their credit's so bad it can't get much worse, and then they file bankruptcy too.
That's really interesting because you admire somebody who keeps fighting the good fight, but only to say, you mean all that effort that I put in, I just kept digging myself deeper and deeper into a bad credit rating. I finally gave up, but now my credit's even more shot.
It's worse than it would have been otherwise.
That's kind of counterintuitive. Yeah.
Yeah, but some people, that's a hard decision because most people have a hard time. I've never had anyone that comes in to me for bankruptcy and, I always dreamed of filing bankruptcy once when I was older. Yeah. That's never anything that anyone wants to do, and so it's a hard thing for some people. With pride or whatever it is that that you've determined, or your own moral code, that's not something you do, and then they end up having to do it.
Or even just as simple as I would hate for someone who owes me money to stop paying me. I don't want to be one of those people. Yeah. But what you're saying is, sometimes you're saying, look, if you're just going to get deeper and deeper into the hole, you're of no benefit to your creditors anyway. They may get burned by this bankruptcy, but bankruptcy exists because people recognized some people just need a fresh start. Nobody benefits from having you get further and further into the hole. The creditors are still unhappy. Yeah, you may be paying them a little, but they're still not getting fully paid. It's better to just get you out from under that crushing debt so you can start to live again.
That fresh start is just what that is. It's you wipe the slate clean and you get to start over, and hopefully bankruptcy is not a Band-Aid for a bigger problem. Periodically, I have people that come in repeatedly. I had one once, an older couple, and it was their 16th bankruptcy in their life. I mean, people like that, they don't learn their lesson the first time.
Jeez,
and they live the same way beyond their means, and periodically they've got to file again.
Or their life plan includes filing bankruptcy every few years.
Right, that's their life plan. But there are some limits there. You can only file a Chapter 7 once every 8 years now.
Okay.
And so there's some limits that you have to consider. 13s you can file whenever, but you don't get a discharge at the end of it if it's too recent from the last filing. So there's some rules on that. And again, that would be a question for
I'm glad you brought that up, because you just can't do a serial bankruptcy filer.
No.
Not very easily, at least.
Not very easily. There are some limits to that for sure. So sometimes bankruptcy is better for your credit, but it's a personal decision as to whether it's worth your while or not. I've had the smallest amount. I think I filed a bankruptcy once for only $5,000 of debt. Mm-hmm. Don't recommend that generally, but it was a single mother who her check was about ready to get garnished, and if it got garnished, she wouldn't be able to make her payment for her home, and it was her and her child was going to get thrown out on the street, and for her it was worth it to be able to keep protecting and
didn't have very good credit anyway, so
to them it was worth it, even though it was a small amount. Most people don't file for anything less than, say, maybe $10,000, but again, it depends on the person. I have clients that wouldn't dream of filing for under $100,000. I mean, it just depends on their position and the money they make. But it's a very personal decision. It's a hard one for a lot of people, but sometimes it's better for your credit than not. It's just can you make your payments or not? If you can make your payments, then it's better for your credit not to file bankruptcy. But sometimes when you weigh the cost of bankruptcy versus the cost of paying the creditors back, let's say you owe 40 grand, and to file bankruptcy, one of the costs is your attorney's fees. Most attorneys are between $1,200 and $1,500 a month for a basic bankruptcy. If it's a business related kind of debt case, then it's different often. But $1,500 versus $40,000, how long is it going to take you to pay $40,000 back versus this? It'll ding your credit. That's a cost as well. But again, weighing those options, you kind of have to decide what's in your best interest.
Going back to that triangle then, and I think this is the last question I wanted to have, is that you talked about, well, you declare bankruptcy and then your spouse is left holding the bag. Those creditors are not governed by the decree of divorce. When it says we're going to divide the debts up, husband pays these, wife pays these, the creditors were never even told. They weren't included in the case, and so they're not bound by the divorce decree when it comes to who pays the debts. So husband then says, yeah, I'll take on these debts, knowing full well I'm going to declare bankruptcy. Declares bankruptcy. Now wife is left holding the bag for everything. Or wife declares bankruptcy, now husband is left holding the bag. You talked about how you could still say, now, what if I get divorced, then I declare bankruptcy, and I name my spouse as one of my creditors? Can I then leave her holding the bag and she can't come after me for not complying with the decree?
There are differences in the law between Chapter 7 and 13.
Okay.
In a Chapter 7, to be really simple, to simplify it.
Okay.
Anything
to oversimplify, but for the sake of this, right.
To make it easier to understand, pretty much anything in a that's been ordered in a domestic case is not going to go away. Your obligation is not going to go away in a Chapter 7.
Your obligation to pay it to your spouse. I mean, the obligation to your spouse to pay it.
Right. So in that triangle, your obligation through your decree between you and your spouse, your obligation to them will not go away in a Chapter 7. If it's been ordered in a decree of divorce, she can go after you for contempt for not following that order if you don't pay it. Even though you lost your obligation to the creditor, if it says you pay that credit card and you didn't, she can have you held in contempt for not following the order.
Okay, so what? So I'm held in contempt. Big whoop. What does that mean?
Then you get a judgment from your...
She gets a judgment against me.
She gets a judgment for you, against you, and then she can garnish your wages.
Even though I already discharged the debt in bankruptcy?
She has not been discharged. Your decree holds you liable still. The code specifically allows Chapter 7 not to get rid of things in a decree of divorce, in a domestic relations case. The difference is in a Chapter 13, though. Chapter 13, the code specifically says you cannot get rid of alimony or child support, but it doesn't mention other types of debts. That's not considered a support type of a debt.
Isn't that the same for Chapter 7 too? I mean, can you discharge alimony and child support in Chapter 7?
Yeah. No, you can't. It's the same, but in Chapter 7, the code specifically says, well, if it's in an order that took place in a domestic case, then you can't get rid of it. But in the 13, it's different. You can't get rid of child support and alimony, but it doesn't say anything about the credit card.
Apportioning the debts.
Right. Okay. So a Chapter 13 is a repayment plan for 3 to 5 years. Well, the way the code is, if you finish a Chapter 13 case and get a discharge at the end for whatever has not been paid back in your plan, then you're discharged for the rest of it, but it also gets rid of your obligation through your decree if you have an obligation like that. So there is a difference there.
Can you protect yourself against a discharge in 13 when you're doing your divorce planning?
You can if you word things right in your divorce planning. So you would want to make sure that it states that obligation isn't necessarily a credit card. You're going to have to somehow put it in the form of saying, well, this is a support payment of some sort. So you're going to have to, and there's some case law and some different types of things out there that you'll want to make sure you meet. And there's a lot. This is a really muddy kind of a difficult area. But basically, you can,
if you use the right magic words.
If you use the right magic words, and you're going to want to make sure you talk to your attorney about making sure that they do their research and can get that right. There's lots of cases on what types of things work and don't work, and so you'd want to look at that to make sure. But the code does allow you to get rid of those kind of debts in a 13. So to protect yourself from it, it would be a feat that the other party may not agree to. to change the language.
If they're
such.
savvy about it. And
They may not say, I'm not going to agree to sign this because you're saying this is considered alimony, and I'm not doing that. So, that's back in your divorce court when you're in there trying to settle the case. You may not be able to settle if you can't agree on the language.
Okay. Well, as you can see, where financial problems may be a source of or an exacerbating problem in marital problems, you want to make sure that you look at bankruptcy at the same time you're contemplating divorce, as to the timing, the order you file, and how you would structure both your bankruptcy and your divorce. I appreciate you taking the time to do that. Now, for those who may be in that very position we talked about, would you please give them your contact information, so if they want to file for bankruptcy, they can give you a call?
My direct number is 801-682-5234, and an email address, jeremy@jeremyatwoodlaw.com.
Thank you very much.
Okay, nice.